Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. You know, the defense counsel has so many opportunities to attempt to get rid of the plaintiff's case. Of course, the tool they use is the motion to dismiss. And there are many grounds on which they, file their motion to dismiss. But I want to give you everything that I know to help you keep your case alive. And today's topic is one of them: standing to sue. Did you know that if you file a lawsuit in the federal court and one of the Article 3 courts, you must have standing to sue? You need standing to sue. And that is what we're going to talk about today. But before we get into that, let me just briefly talk about the Article 3 federal courts, because I don't believe I talked about the Article 3 courts in depth. The Article 3 courts or Article 3 judges are the Supreme Court justices, federal circuit judges, and district court judges. These judges are nominated by the President of the United States and confirmed by the United States Senate. Article 3 of the Constitution governs their appointment, their tenure, their payment, for example. So before you file a lawsuit in the Article 3 courts, we want to make sure that you have standing. So let's get started. What is standing, or what does it mean? Standing means the person filing a lawsuit against another party is the proper party to request adjudication or compensation. Federal constitutional law has established three main requirements. I call them the key requirements for standing to bring a lawsuit. The first one is injury in fact. The plaintiff must personally have suffered some actual or threatened injury in fact. Two, causation. The injury must be traceable to the actions of the defendant that caused the injury. Three, redressability. The plaintiff must demonstrate that the injury is likely to be redressed by a favorable decision. Now, I like to demonstrate my videos by using case law because, of course, this is what we do. We submit our arguments with our facts and our case law to show that a precedent has been set and to show that our case has credence. And the case we are looking at today is Beno versus American Bar Association. It's a 2016 case, and it is cited at 826 Federal 3rd 338. Now, Beno is legally blind, and he applied to 3 law schools in Michigan. He claimed that he was denied admission because of poor LSAT scores that were the result of discriminatory testing that he alleged was mandated by the ABA. Now, Benno sued under three statutes: Section 309 of the ADA's Title 3, 42 USC 12189, and Section 503 of Title 5, 42 USC Section 12203B. Now, I cited this because this is part of the case, but also I want you to know about these statutes. So let me go over them briefly. With regards to 309 of the ADA's Title 3, what it essentially says that entities must provide public accommodations. 42 USC 12189 addresses examinations and courses also being made accessible to the disabled. And Section 503 to USC 12203B addresses coercion against someone because they complained or that it violated their right to free speech or their right to complain. Now, in this case, Benno requested only equitable relief. One, he asked that a declaration be made that the ABA violated his rights under the ADA. And I am going to do a video on declaration. We did a video on injunction, and I'm going to do one on declaration so you can see the difference between the two. Two, he asked for an injunction preventing the ABA from accrediting law schools until the ABA, quote, ceases implementation of Standard 503. And I just went over 503. Three, an injunction preventing the ABA from applying Standard 503 to himself and other legally blind or visually impaired individuals. Four, that an injunction be ordered restraining the ABA from discriminating against individuals with disabilities and requiring that the ABA provide individuals with disabilities with full and equal access to the programs and services of law schools. In a nutshell, Benno wants the ABA to change its policies on blind applicants and the LSAT. Specifically, he quote, "I want the American Bar Association to stop telling blind people that they have to draw pictures in order to go to law school." May 25, 2011. So what do you think? How did the court rule? Well, here is the judgment. The district court judge granted the ABA's motion to dismiss, holding that Benno had sued the wrong party, that he lacked standing to bring his action, and that if he did have standing, he failed to state claims for relief under Title III and Title V of the ADA. So now let's look at them specifically. On the first element, injury in fact, the ABA did not dispute it. The ABA does not contest that Benno has a legally cognizable injury in fact. Now, on causation, Benno had a problem. The court stated there are no allegations that the ABA itself directed these questions to be included on the LSAT. And here's the problem. Because it was the law schools that Benno applied to who determined the weight to give Benen's LSAT scores. Further, the entity in control of the LSAT's content and format is not the ABAs, but the LSAC, a totally different entity, not connected with the ABA at all. So, no, the court can't make a favorable decision on behalf of Benin because one, the proper entities would have been LSAT, LSAC, and whoever else might be involved or connected. But neither of these parties were named in Benin's lawsuit, and that's a problem. You see how this works? All right, read the case if you can. It is a good read. All right, then. You guys take care and keep pushing, okay? And I'll see you next time. I'm Advocate Lucinda B. M. Powered.